matter of State versus Grant Spencer. And he appeared for Justice Spencer. Who's appeared for Mr. Spencer?
Mr. Hube and Ms. Totten.
Okay.
All right. All right, this is case number SU 14 CR 618 State versus Grant J. Spencer. Mr. Spencer's in lockup. Steve, if you would bring Mr. Spencer out.
Yeah, you're fine. Stay right there. Well, okay.
Clerk will replace Mr. Matthew is here on behalf of Mr. Spencer, and Mr. Spencer is in the courtroom. Ms. Totten represents the state. Mr. Hube, your motion.
Thank you, Judge. Before we get started, I wanted to make sure that the court and the state has a copy of the sentencing transcript. I have a copy for the court here. Okay. And I've got some law as well. All right. Daphne, do you have a copy of the transcript? Okay. And I printed just the good sections pertinent to the UK interview on that, or do you have those? Yeah, I think it's pretty. So Judge, I've got a copy of the sentencing transcript, copy of the code sections that make up the Georgia Youthful Offender Act, and a copy of 17-10-1, which is the code section that the state has cited in their reply brief. With the court, a little bit of background on this case, since you did not preside over it originally. There was a guilty plea in this case on October 11th of 2016 to voluntary manslaughter. And there was a 20-year sentence imposed, and that was a negotiated sentence. The incident that led to this prosecution happened when Grant was 20 years old. He had been 20 for about a month when this happened. He's now 27 years old. He spent about 2 years in the county jail and has been in the prison system for about 5 years, thereabouts. So 7.5 years total incarceration between our county jail and the prison system. I want to make sure that the court understands that we're not here to ask that you reduce his sentence, give him lenient treatment, let him out earlier, put him in a better position for parole. We're not here asking any of those things. I also want to be clear that Grant has been punished and he continues to be punished. And quite frankly, talking to him during this prosecution and yesterday we spent a couple of hours together, he'll be punished for the rest of his life. That's something he thinks about every single day, every single hour, every single minute. of every day, and him not being incarcerated is not going to change that. So I don't want anybody here to think that he's not been punished and is not being punished. He relayed to me some stories about going to prison and what that was like, and having to stand up to people and fend for himself, and how he had to avoid getting involved with gangs who offer protection. You know, hey, join us and we'll make sure these guys don't mess with you. And he's been able to avoid all of that. Frankly, it was an eye-opening conversation for me, despite having represented a lot of folks that have ended up being incarcerated. It really made it more real. So, as I indicated, Grant is now 27 years old. He currently is at Walker State Prison, which is just south of Chattanooga. We outlined in the motion all of the things that he's been able to accomplish while he's been incarcerated. I'm not going to read through those. They're listed. I do have supporting documentation if the court wants to see all of those certificates, but that's what they are, certificates that say he's completed this program and that program. And again, they're all listed in the motion. He, at Walker State Prison, teaches a class on investments to other inmates. He works in the metal shop there at the prison, and they make furniture that's used in prisons across Georgia and in other states. They make grills and picnic tables that you see at the state park. He's not paid for that work, but he does have the opportunity to go to a job, so to speak, on a regular basis. The only, and you've seen, he's been able to graduate from college. He's got a college degree. And he's been through all of these programs and taken advantage of all the training opportunities that are available to somebody who's in the prison system. The only thing that he has left that he can do with regards to programs is to complete a welding program. He's been involved in the welding program for a while. He's got a 5-month training course in stick welding left to complete. Once he finishes that part of the program, he'll have a degree in welding technology from a technical school. After that, he's done. There's nothing else that's available to him in the Department of Corrections at this point that he can take advantage of. Except that if sentenced under the Georgia Youthful Offender Act, there may be some additional doors open to him with regards to programs, training, those types of things that he could be involved in. Specifically, there is a firefighter program within the Department of Corrections. And it is what it says it is. Inmates are trained to be firefighters. And that can, and sometimes does, result in somebody being able to gain employment in that field when they're ultimately released from prison. If Mr. Spencer's sentenced as a youthful offender, he has a chance of getting into that program. Without youthful offender, it's very doubtful that he would be able to enter that program. And I think there may be some other programs afforded people who are youthful offenders or sentenced as youthful offenders that otherwise other inmates are not afforded the opportunity to be a part of those programs. To go through a little bit of the law on youthful offender, because it's not something that I was familiar with in any detail prior to this case. It's not something in our circuit that we typically deal with. I know I can't remember another case that I had personally where we even requested that somebody be sentenced under the Youthful Offender Act. But people who are eligible have to be between 17 and 25 years of age at the time of conviction, and Grant was within that age bracket at the time. Can't have a death sentence, can't have a life sentence. Those people would be ineligible. And basically, if you read the code sections, this program is for rehabilitation. It's for people to have training and be involved in these different programs that are offered in the Department of Corrections, so that when they do get out of prison, they'll have some skills so that they can get into the outside world and live a life, be employed, and re-enter society and hopefully not re-offend. And so these are vocational, educational, and other training opportunities that are deemed fit and necessary by the Department of Corrections. And we've cited some of the language from some of the code sections in our motion. And so that's really what this is about, is to try to get into some of these other programs that otherwise Grant is not going to be eligible for. There's a couple of really important things about youthful offender that I want the court to consider. Number one is, if you grant our motion and say, okay, he's sentenced as a youthful offender, that doesn't mean that he gets that treatment or that status in the prison system. Ultimately, that decision is up to the Department of Corrections. There's a process that a person goes through for the Department of Corrections to decide if they're a good candidate for that program, and if they are, presumably they let them in. If they are not, then they don't let them in. So just you saying, I'm going to sentence you as a youthful offender, doesn't mean that's the end of the story. He's not automatically in. Somebody else takes, frankly, a much closer look at it than we're going to be able to take today. The other thing that's important for the court to understand is this doesn't affect parole in any way. In fact, part of the Youthful Offender Act states that explicitly. OCGA 42-7-9C provides in part that a person sentenced under this chapter shall have his eligibility for parole imputed in the same manner as other offenders sentenced to the jurisdiction of the department. So he doesn't get any preferential treatment with regards to parole because he's in the youthful offender program. Doesn't change anything about parole. It just means there's some other programs that you might be able to participate in. Now, obviously, he was not sentenced under pursuant to the Youthful Offender Act when he was sentenced back in October of 2016. We did request that. That was not part of a negotiated plea, but I do recall having a conversation with the state prior to sentencing about the Youthful Offender Act and about the fact that we were going to ask for it. On the transcript, if the court will turn to page 69, right in the middle of that page is some language from Judge Woodrum about the request to sentence under the Youthful Offender Act. And Judge Woodrum said, so the court at this time is going to decline your request for sentencing under this Youthful Offender Act. So that language is very important, at this time. In my mind, that leaves the question open, just like some judges in some cases say, I'm not going to set a bond at this time. That gets revisited later. And so what we're asking the court to do...
But bond's always subject to revisitation.
It is. It is. But because this was left as an open question and the court never made a decision, ultimately what we're asking the court to do is to answer our request to sentence Grant under the Youthful Offender Act. Now, in the state's reply they have cited to 17-10-1, which is a code section that essentially says a court can only modify a sentence after 1 year from the date of sentencing. Clearly, we're well past that 1 year mark. But if the court will turn to page 5 of the code section that I supplied, 17-10-1, and look at subsection F, as in Frank. If the court reads that paragraph, this is the subsection that the state cites to say, you can't, judge, you can't modify this. It's out of your hands. You have lost jurisdiction. Well, that may be true in some instances, but I don't think it's true here. And here is why. If you go to the second sentence, you'll see where it says whichever is later. So I want to draw your attention to the language that is directly after that. The court imposing the sentence has the jurisdiction, power, and authority to correct or reduce the sentence and to suspend or probate all or any part of the sentence imposed. Those are the things that this code section talks about being able to do within a year of conviction, but not be able to do outside of a year of conviction. So in looking at that a little more closely, you can't correct the sentence. We're not asking you to do that. You can't reduce a sentence. We're not asking you to do that. You can't suspend a sentence. We're certainly not asking you to do that. And you can't probate a sentence. We're not asking you to do that. We're not asking you to do any of the things that are specifically prohibited in 17-10-1F. Now that code section does go on to use the word modify, but I think that word being read along with the list of things that we just went over is talking about this. So that the language further says, prior to entering any order correcting, reducing, or modifying any sentence, the court shall afford notice and an opportunity to be heard. In other words, the state has to have their say. There has to have to be a hearing. So modification is related to suspending or probating any part of the sentence. Again, the language says you can't correct, you can't reduce. Those two words are specifically mentioned in the list of things that the court's prohibited from doing. And then it says, or modifying any sentence. The modifying part relates back to suspending or probating. And again, we're not asking for you to do any of those things. 17-10-1F does not apply to what we're asking the court to do. Now, in the state's reply, they make some statements about the intent of the sentencing judge is clear in the sentencing transcript. And that's not what the sentencing judge intended. I don't know how anybody can know what Judge Woodrum intended except Judge Woodrum. What we do know is that he did not make a firm decision at the time. He left it an open question. I'm not going to do that at this time. The state also calls our request disingenuous. I take exception to that. There's nothing disingenuous at all about me representing my client, and that's what I'm here to do. Finally, and I think most importantly, the fact is Grant Spencer's being got personal. Some people in this room don't like that idea, probably. Some people in this room can't wait for that day to get here. But it's going to happen. It is an eventuality. And it's a certainty. So if we understand that, and we know that Grant Spencer is going to be in the community, living with the rest of us, why would we not want him to be able to take advantage of every opportunity that's going to potentially result in him being able to make that transition in a more successful way? Why would we not want that? Isn't that ultimately what we want? You commit a crime, you get punished, you serve your punishment, you re-enter society, and you contribute. And you live amongst the rest of us and you don't cause mayhem. Well, it's no secret and it's no mystery that people who can take advantage of training opportunities and get out of prison with some skills have a much better success rate at not reoffending. And I think that's a very important thing, is to realize he's going to be out in the community, and why wouldn't we want to afford him every opportunity to gain some skill in order to make that successful transition. So we ask that the court sentence Grant Spencer retroactively under the Georgia Youth Bulloch Act. Thank you.
Sure, thank you. May it please the court. We did file a written response, and I'm going to touch on just a couple of things that are included in our response, and also have a few other things to add. I'm glad that Mr. Hube referenced the transcript that is part of the official record in this case, because there's a few things in the transcript that he did not talk about that I want to bring to the court's attention that I think are extremely important as far as the state's position on this motion goes. We do oppose this motion, Your Honor, and we respectfully are asking this court, who we understand was not the original judge that presided over this case, nor were you the judge that was here the day that a negotiated plea was offered to Judge Woodrum. But it was a negotiated plea. What had transpired leading up to all of us appearing back on October 11, 2016 was plea negotiations between the state and Mr. Hube and Mr. David Wolf, who also represented Grant. Included in those discussions were the Gattos. Present in court today are the parents of Michael Gatto, Michael Gatto Sr., as well as his mother, Ms. Catherine Gatto. They were very involved in this case at every stage of the process. They were present for motions. They were here for the day that we had the negotiated plea. And when we showed up that day to enter what was supposed to be a negotiated plea, at no point prior to all of us appearing that day had the Youthful Offender Act ever even been part of our discussions. The state was approached by David Wolf immediately prior to the hearing beginning and asked if the state had any objection to Mr. Spencer being sentenced under the Youthful Offender Act, to which we did. To be quite honest with the court, we were beside ourselves because that was not something that had been part of the back and forth negotiations. It's not something in my 18 years, today I stand here, I've been in the DA's office for right at 18 years, and it's not something that we've ever used or that has been used in a murder case that started out as a felony murder case. And I'm not saying it's never been done in this circuit, it may have been, but this was not something that was part of the core of our plea negotiations. And the negotiations that took place that ultimately resulted in an agreement to a plea of voluntary manslaughter with 20 years on that sentence to serve, that was something that had been discussed and agreed upon by everybody. The youthful offender thing that was brought up literally at the 11th hour took the state by surprise. It took the Gatto family by surprise. And for those reasons, we asked the court not to do that, and we objected to it. Mr. Hube has said today that he cited the statutes that talk about youthful offender. The court's got a copy of those, so I'm not going to go through and read those. But one of the statutes that they have not mentioned today, that the state talked about, that's reflected in the transcript, is OCGA 42-9-45, that talks about if someone is sentenced under the Youthful Offender Act, that code section provides that when an inmate is sentenced pursuant to this code section, he or she may become eligible for consideration of parole after they've completed at least 6 years of their sentence. And that specific statement, that they could become parole eligible after 6 years, that's in paragraph B of OCGA 42-9-45. Now, that's not in the statutes that Mr. Hube provided the court a copy of. I'm going to get the court a copy of, I think I've got it right now. Got all the annotations, but this is 42-9-45, general rulemaking power, and this pertains to the pardon, paroles, and other relief. The board may adopt and promulgate rules and regulations not inconsistent with this chapter, touching all matters dealt with in this chapter, including, among others, the practice and procedure in matters pertaining to paroles, pardons, and remission of fines and bonds and forfeitures. The rules and regulations shall contain an eligibility requirement for parole. We shall set forth the time when the automatic initial consideration of parole inmates under the jurisdiction of the Department of Corrections shall take place, and also the times at which periodic reconsideration thereafter shall take place. Such consideration shall be automatic, and no written or formal application shall be required. And if you go here to paragraph B, it talks about if they are sentenced as a youthful offender, that after the service, it says serving sentences aggregating 21 years or more, they will become parole eligible upon completion of 7 years. Above that, it says an inmate serving a felony sentence or felony sentences shall be considered for parole after the expiration of 9 months of his or her sentence, or 1/3 of the time of the sentences, whichever is greater. I'm going to provide this. This discusses at length the general authority and general power of the parole board. And this was a crucial part of the state's argument back when we appeared before Judge Woodrum, because a recommendation by the court that Grant be sentenced under the Youthful Offender Act, it would in essence modify the agreement, which was a joint agreement, to what his sentence would be, which was 20 years. Being eligible for parole after 6 or 7 years, or 1/3 of your sentence being served, is wholly different than what the guidelines say. And we referenced those in the transcript on page 62. We talked about that normally under the traditional sentencing guidelines with the Department of Corrections and the Pardons and Parole Board, that a level 8 offense is subject to the person serving 65 to 90% before they are parole eligible. Voluntary manslaughter, as the court knows, is a level 8 offense. It still is. The 65 to 90% before parole eligibility is still what the guidelines indicate. And so, again, I just want to state in my place, for the record, that is the primary reason, along with the fact that this was not something that was contemplated during our negotiations, that by sentencing him under the Youthful Offender Act, it would do something that is entirely different than what the guidelines say. It would, in essence, make him eligible as soon as 1/3 of his sentence is served, which will be between 6 and 7 years. In addition to the arguments that I wish to make here today, Ms. Catherine Gatto is here, and she would like to be heard. She has brought with her a prepared statement. She would like to address the court on the feelings that she has about this, as well as the feelings that the family of Michael Gatto have. And I would like to call her in just a moment. But as far as the actual law goes in the state's position, we would still take a position that is outlined in our brief, which is that there's no really provision in the law that would allow the sentence to be modified at this juncture. We would also disagree with, I guess you would say, the characterization of these words that are contained in the transcript at this time. I would agree with Mr. Hube. I guess the only person ultimately that could answer what that meant would be Judge Woodrum himself, but I would not agree with opposing counsel that Judge Woodrum left this open for discussion, because Judge Woodrum did in fact hand down a sentence. The sentence does reflect that he was sentenced to voluntary manslaughter 20 years, and he did not sentence him under the Youthful Offender Act, or rather, as the statute says that the court would do, he did not recommend the Youthful Offender Act treatment for him. Now, if Mr. Hube or Mr. Wolf had wanted the court to revisit this issue, they could have had Mr. Spencer file a motion to withdraw his plea. Within 180 days, they could have filed a motion for the court to reconsider. They could have done a lot of things, but those things weren't done. We're now over 6 years past the actual sentencing, and we would take the position that we put in our written response that there's nothing in the law at this point that would allow the court to modify the sentence. And sentencing him or recommending that he be sentenced under the Youthful Offender Act would be a modification of the sentence. And it would essentially, if the parole board were to look at the recommendation and place him in the program, then it would actually result in him being paroled much earlier. And that was not what was contemplated when we had this negotiated plea agreement. This case started out as a felony murder case. It took place at Rude Rudy's, and at the time, as Mr. Hube said, Grant was a 20-year-old student. He was also working part-time as a bouncer at Rude Rudy's. And Michael Gatto had gone this particular evening with some friends to Rude Rudy's as a patron. What we would have expected had been presented at trial, had we brought in witnesses who would have testified to what took place that night. There was another patron who had consumed alcohol, who was standing next to Mr. Gatto, who thought he saw Mr. Gatto take $20 out of a tip jar. He thought he saw Mr. Gatto reach his hand down into a tip jar and essentially steal money out of a tip jar. That other patron, who had consumed over a pitcher of beer, alerted the bouncers and the bartenders behind the bar to what he saw, or rather what he thought he saw. There was really good video footage that was obtained during the investigation, and what that video footage showed was that Michael Gatto did not stick his hand in the tip jar. Rather, his $20 bill that he was holding out to try to buy some beer fell out of his hand behind the tip jar, and he reached his hand over the jar and he picked up his own $20 bill. And that was very clear on the video. And after this other patron saw what he thought was Mr. Gatto taking money out of the tip jar, the bartender behind the bar proceeds to have a conversation with bouncers, who then approached Mr. Spencer was one of those, but Mr. Spencer was the one who got there first, and he was followed by some other bouncers. Mr. Spencer, notably that night, was not actually working. He was just there, presumably as a patron, but he was not technically on duty that night. But what the video footage further showed was that Mr. Spencer grabbed Mr. Gatto by the neck and proceeded to punch him multiple times in the temple of his head, causing multiple injuries to his skull, his brain, that ultimately resulted in fractures and bleeding that led to his eventual death. The words unprovoked attack were used a lot when we were here previously in previous hearings, because it wasn't an unprovoked attack. Michael Gatto was not stealing. Michael Gatto was not involved in a bar fight. Many of these cases that we have had through the years that happen at bar establishments have involved what we have coined bar fights. This was not a bar fight. This was a college student that went there with friends and unfortunately did walk out that night. The negotiations that took place that resulted in the state agreeing to reduce the felony murder charge, those plea negotiations and that ultimate lesser sentence that was extended as an offer to Mr. Spencer, that was done only with the blessing of the Gattos that are sitting back here. It wasn't done because anybody viewed their son to be in the wrong. They recognized how young Grant Spencer is. They recognize The fact that at the time this occurred, he did not have any felony convictions on his record. And so they were compassionate, in a sense, more than compassionate, and that they were willing to join in the state making that recommendation. And all the things that Mr. Hube has argued today and previously, the state took those into consideration in agreeing to extend this offer of voluntary manslaughter. At this time, I would like to call Ms. Catherine Gatto to the stand and give her an opportunity just to read her statement into the record and address the court and state anything that she would like the court to know.
Ms. Gatto, if you would please come up to the witness stand. And before you're seated, if you would raise your right hand. Do you solemnly shall be the truth, so help you God? Thank you, ma'am. You can be seated. Ms. Gatto, that mic in front of you is an area mic. If you will pull it to you, just speak across the top of it, and it should pick your voice up.
Good afternoon, Your Honor. My name is Catherine Gatto, and I'm the mother of Michael Joseph Gatto, who is the youthful victim in this case. I'm grateful for the opportunity to speak today on behalf of my son. It is also traumatizing to be back in the same courtroom again, in the presence of my son's murderer, asking again for justice for Michael. Michael was just a teenager when he was beaten to death by Mr. Spencer in an unprovoked, vicious, one-sided attack. Unlike Mr. Spencer, Michael will never get to finish college or have a career in engineering, which was what he had planned. He will never travel and see the world, which was his desire. He will never get married or know the joy of having children or grandchildren. His entire adult life and all that it would have encompassed was taken from him by Grant Spencer. Accordingly, my family and I are adamantly opposed to resentencing Mr. Spencer under the Youthful Offender Act. Mr. Spencer was already awarded a plea deal which significantly reduced his sentence. The notion of an additional reduction or reward for Mr. Spencer would be an insult to Michael's memory and would serve to further victimize my family and me. Michael was my first child, the oldest of my 4 children. He was a beautiful person. I was enormously proud of him. He was a loving son and big brother, and he was part of a large extended family who loved him very much. He was personable and engaging. He had a great sense of humor and a contagious smile. He enjoyed being around people. He was a wonderful artist and an accomplished athlete, achieving his black belt in karate at age 9. Played soccer and basketball and was a county champion in high school track. He loved animals, strawberry Twizzlers, sports, the beach, his car, his music, his friends, and most especially his family. My son was looking forward to attending college at Georgia Southern. It was an exciting milestone for him and for us as parents. It was supposed to be the beginning of a new and wonderful chapter in his life. I remember the day he left for college. I hugged him tightly and I told him that I loved him and to be safe. And it would be the last time that we would share a hug. 2 weeks later, Grant Spencer killed him and my son was gone. The ripple effect of this crime has been far-reaching and devastating to many people. In addition to my husband and to me, Michael's friends, aunts, uncles, cousins, grandparents, and most especially his 3 siblings have all been greatly affected. My elderly mother has never recovered from the loss of Michael, who was her first grandchild. It disgusts me when I think of the intentional, unprovoked, violent actions of Mr. Spencer and what those actions have done to my once happy family. My children were 15, 13, and 11 years of age when Mr. Spencer murdered their big brother. Michael's siblings, Megan, Matthew, and Michaela, are the often forgotten victims of this crime. Their parents, their lives, and their futures have been forever altered by their big brother's violent murder. And while I've spared them the stress and pain of being present to describe what this crime has done to their lives, I ask that the court not forget them today. asked that their grief and their pain be taken into consideration as they continue to suffer. They did submit written statements for your consideration.
And Your Honor, I've given Mr. Hube a copy of these, and we have marked them as State's Exhibits 1 through 5, which includes Ms. Gatto's statement. We would just like to tender these to the court as victim impact statements from the Gatto family.
And Mr. Hughes,
No, Your Honor.
admitted.
My children and my family are the most important thing in my life, Your Honor. As Michael's mother, I put my heart and soul into raising him. I provided him with love, guidance, experiences, and support in the hopes that he would live a long, healthy, happy, and productive adult life. I looked forward to seeing the man he would become and all the wonderful things he would do. Like any parent, I had dreams for him, and when Grant Spencer killed my son, he killed those dreams. He took the incredible boy I spent 18 years loving and nurturing, and in minutes he eliminated him. Because of Mr. Spencer's choices, my husband and I have had to endure things that no parent should have to endure. We've had to kiss our child for the last time and leave his hospital room knowing we'd never see or touch him again. We've had to make funeral arrangements and clean out his dorm room. We've had to sift through and box up Michael's clothes and his treasured possessions. We have had to experience holidays, birthdays, and other special occasions without his presence. We've had to see Michael's friends grow older, graduate college, and get engaged, knowing our son will do none of those things. We've had to live with the knowledge that our son's last moments were spent in fear and in pain. And we've had to get up and face each day knowing that our son is dead. I think about my son every day. I wonder what he might have become and what he might have accomplished if Mr. Spencer had allowed him to live his life. I mourn the lost time with him, the things I'll never get to tell him, the grandchildren he will never share with me. I want to hear his voice again, or to hug him, or to tell him that I love him and that I'm proud of him. I miss him profoundly. To this day, I cannot accept that he's gone. I suffer insomnia, anxiety, and anger. I've been rendered incapable of feeling any genuine joy. It's still difficult for me to socialize, celebrate, or smile, and there is a black cloud over everything I see or do because of Mr. Spencer. The permanence of Michael's death is physically and emotionally exhausting to process. Mr. Spencer didn't just end my son's life, he has ruined mine. He has given me a life sentence. This is my son, Your Honor. Michael's life mattered, and he had the right to enjoy a long and happy life. It's reasonable to assume that my son had 60 years or more of life left to experience. 60 years. Mr. Spencer stole those years from Michael. Mr. Spencer's violent actions had permanent, irreversible consequences for my son and for the people who loved my son. Michael's life should not be forgotten, devalued, or disrespected by this outrageous request to resentence his killer. Michael was murdered exactly 3 months from the day of his high school graduation. He is a youthful victim. There is no community service, certificate of completion, or any other achievement by Mr. Spencer that could possibly lessen or somehow compensate for the commission of this brutal murder or the pain that it has caused my family and me. To suggest otherwise is an offensive attempt to both diminish the value of Michael's life and the significance of losing him. So I'm asking the court to please honor and value Michael's life by denying this motion. Thank you. Thank you, Your Honor.
Thank you. Any other questions?
No other questions? No other questions for Ms. Gatto? Just got a brief argument, I'll let Mr. Hube ask any questions he might have of Ms. Gatto.
Any questions?
No question, Your Honor.
Thank you, Mr. Totten.
That would be the only witness that the state would intend to call, Your Honor. In addition to states 1 through 5 that are in the record at this point as victim impact statements from the Gatto family, the state also has brought copies of other statements, in fact 186 pages worth of statements that were offered to Judge Woodrum previously, and those are available if the court would like to see those. Those are things that were offered years ago when we were here that were taken into consideration by Judge Woodrum that were family members and friends of the Gatto family.
Are they a part of this transcript?
they're not attached as an exhibit, that they were previously reviewed by the court.
Notice there were some exhibits that were attached.
Right, that's correct. We did not, I don't think we did not put them in as an actual exhibit.
Are you tendering them today?
Well, I'm saying I can do that. I can do those as a cumulative exhibit 6. But they were written back in 2014 when this took place. We also brought a copy of the video. If this court would like to view the video at any point that shows the attack that took place and what led to Mr. Gatto's death. This court, I know, is in a unique position in that it did not hear all the other things that led up to the plea. There was a preliminary hearing and some other hearings that were held. But what I would like to say in closing is this. This court granting this motion, they don't call it a motion to modify because they know that the law doesn't allow a sentence to be modified at this juncture. But a sentence at this juncture in the case, over 6 years in, under the Youthful Offender Act, as outlined in the law that's been provided to the court, specifically OCGA 42-9-45, indicates in paragraph B that after someone's completed a third of their sentence, that they would become eligible for parole. And we would also say that if the court would like to view the video shows what the evidence in the case
Let me say in
indicated.
that regard, I hear that often by lawyers, if the court would like to. The court's not in the business of entering evidence. If you offer the evidence, the court will consider it.
Well, we would like to offer that then, as State's Exhibit 6. And we brought a laptop and we can set it up and let the court view that. It'll take just a moment to get that set up. What I would say while we're doing that.
If you offer the evidence, the court can play it for itself.
Correct, well, that's correct.
Without the evidence, the court can view it.
Okay.
Judge, we would object to that. I don't think it's relevant to the motion itself. We certainly weren't here to retry this case. State didn't give us any notice whatsoever that this was the plan, or we certainly would have been here to give you a lot of other information that the state's not giving you.
The objections made, the court will overrule the objection and consider it for whatever purpose is helpful.
Daphne, did you say we're entering the statements of this?
State's Exhibit 6 is the video. We would stand on the arguments that we've made already, Your Honor, that this was an unprovoked attack, which is what the video shows. We would also state that it was a negotiated plea, which is reflected in the transcript. And we would respectfully ask the court to deny the motion to re-sentence Mr. Spencer under the Youthful Offender Act, because that would be a modification that is, one, not only not allowed by law, but it is also a modification that would be a direct contradiction of the negotiations that we had back over 6 years ago. We would also, again, take issue and we would not join in the assessment or the interpretation of the comments made by Judge Woodrum. Mr. Hube cited to that specific statement by the court. Page 67 of the transcript is the sentence of the court. Notably, Judge Woodrum said, "Grant, I hope that you clearly understand from all that has taken place here that every human life is a very important, precious," and you could say commodity. That's not really a good definition, but every life is precious. And the person's body that life is placed in is a very precious mechanism and it has to be protected. And it's not something for somebody else to just brutally beat someone and hurt someone and take that mechanism away so that that life is forever gone. And that's what's happened to Mr. Gatto at this point. I hope you understand. And it's probably, things have changed over the years. I think in the new generation, we think everybody's superhuman, they can withstand everything. The body can withstand all kinds of blows, but that's just not the case. Deep down, that life is very, very precious, and that life has been taken away from this young man and his family, and they'll never get over this. And you'll never get over this, and your family will never get over it. In reference to your sentencing, the court goes over several areas. They have to make a determination on the appropriate sentence and look whether it's a case, or whether it's this case or any case. You have to look at the law that's been violated, and there has to be a punishment for that violation. The court also has the responsibility to look at the rehabilitation aspect when it hands down the sentence and make a determination what will be appropriate. Now, your attorneys have argued faithfully for this designation here under this Youthful Offender Act, and I think that is a good thing. I think this is a good thing. I think it's such that folks need to be rehabilitated, but we don't need to look or lose sight of the punishment aspect of it also. And we have to look at the crime that was committed, and the punishment has to be severe in a crime of this nature. I think through the efforts of your attorneys in the state, they've been able to work with you and gave you some opportunity that we wouldn't be sitting here with life without parole or whatever it is that you really would have been faced with if you had been found guilty of the original offense in this case. So the court at this time is going to decline your request for sentencing under this Youthful Offender Act. I think the state's going to give you many resources that's going to be available for you to better yourself while you're in the system. But I think what you need to do moving forward without being sentenced under this youthful offender, from the standpoint that the punishment needs to be severe in the nature of the offense that was committed. So you will be sentenced to that 20 years that you've been able to negotiate with the state of Georgia. And as I've indicated to you through the entry of this negotiated plea, which it was a negotiated plea, you would waive all rights as far as an appeal is concerned. I think when the court looks at the entirety of Judge Woodrum's statements, this court can make its own assessment and interpretation. But Judge Woodrum went through a number of things in explaining, before he pronounced sentence in the case, that he was declining to sentence Grant under the Youthful Offender Act. And the state didn't leave here that day thinking that there was any chance that the court was going to do otherwise. And there was no motion filed to withdraw the plea within the next term of court or the following term of court. And there was no motion filed to modify the sentence. So we would, again, respectfully ask the court to deny the motion. And the last thing I would address is these other documents that I brought. We would like to tender copies of these other 186 pages of what was previously reviewed by the court as a cumulative exhibit, which we state is Exhibit 7.
And that was at sentencing.
Correct.
And,
Same objection to be stated with regards to the
duty notice. Anything else, Ms. Totten?
No, Your Honor.
Here, your motion. Last argument.
Your Honor, I'd like to point out to the court that Mr. Spencer's family is here. His mother, his father, his sister, his brother, and a close family friend are here in support of him. During the 7.5 years that he's been incarcerated, he's had no disciplinary record at all. Judge, despite a strong desire to retry the case, which is what we've heard, I'm not going to do that. I don't think that at this point placing blame on anybody, and certainly Grant deserves blame in this, and that's why he's sitting over there in a black and white jumpsuit. Just going back to Walker State Prison, but I'm not going to get into all of that. The state's position very clearly is a punitive one. Don't let him do this. Don't sentence him pursuant to Youthful Offender Act because he may get some benefit out of that. He may be able to do something that he otherwise wouldn't be able to do. Now, the parole question is an interesting one. Everybody who's sentenced to 20 or more years is eligible for parole after 6.5 years. Grant became eligible for parole in April of 2021. He's got paperwork from the parole board at Walker State Prison that says that. The code sections under youthful offender specifically state this doesn't affect the parole calculation or the parole analysis. Specifically stated in that language. It's in the motion, it's in the law that I've given the court. So he does not get any benefit with regards to parolability that he doesn't already have. Again, all this is about is giving Grant Spencer the opportunity, if the Department of Corrections sees fit, to also give him the opportunity to engage in some additional programs and training that he otherwise would not have the opportunity to take advantage of. And again, restating our position on 17-10-1, we're not asking the court to do the things that are specifically listed in that code section, which are to correct, reduce, suspend, or probate the sentence. We're not asking for any of those. We're asking for the court to go back and ultimately answer the question that Judge Woodman left open, which is whether or not to sentence Grant Spencer as a youthful offender.
Thank you. The court will consider the transcript and the other evidence offered as well as the arguments offered and enter an order. Thank you.
Thank you, Your Honor.
Thank you, Your Honor.